This video contains excerpts from an online workshop that the USALI Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by USALI Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
This is Rule 702, and it's worth just spending a minute on. A witness who's qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion. This is what Ira brought up very early on in the presentation. And then the criteria are itemized below. A, that opinion has to help the trier of fact understand the evidence or determine a fact in issue. The testimony is based on sufficient facts or data. It's the product of reliable principles and methods, and the expert has reliably applied the principles and methods to the facts of the case. I think Chris and I agree ultimately on what Dalbert means in 702. My point was, the minority opinion in Dalbert, the plaintiff's expert who was saying, we've done a bunch of studies and it looks like bendectin is potentially dangerous. That was a compelling opinion, as I've said, for children in this case. And we ought not, the thinking goes, exclude minority opinions just because they haven't gained a majority foothold. Because as we've talked about, minority opinions oftentimes are tomorrow's majority scientific thinking. We ought to, in certain circumstances, allow those opinions to come in. And that way the gate is broadened. But here's really where Chris and I agree. It's not just that the doors to the courthouse were opened more widely under Dalbert. There's also the second half of that story, which is if courts were to follow rigorously the criteria set forth in Dalbert and articulated here in Rule 702, it might well be the case that fewer disciplines were getting into court, not more, because when 702 is followed, the criteria in Dalbert is followed, it may well turn out that a lot of scientific disciplines, which had regularly been admitted into courts consistent with Fry, would not actually meet the standards of Rule 702. Does that make sense? So there, at least in my mind, there was a broadening because we're considering the admissibility of minority opinions. On the other hand, if we were to step back and really take a close look, particularly at traditional, long accepted scientific disciplines, if we were to step back and do that, many of them would actually not meet the standards set out in 702 and Dalbert, and they would no longer be admissible.
So I would just say that the way that I think of 702 as it relates to Dalbert, which can be confusing, is that if you look at C, the testimony is a product of reliable principles and methods. Basically, that's science, is the factors that are listed in Dalbert will tell you that you're dealing with a reliable principle and method if you are applying the Dalbert factors and judging that particular technique. So they relate in that sense. And the advisory committee notes, I think, also say that. And then if you go down to D, they're reliably applied means that you can have a forensic technique or some other basically valid scientific discipline, but that it was applied in an unreliable way. Like DNA, for example, that's contaminated, right, is a really easy example. And so it would be excluded, even though the discipline itself is, obviously very reliable. To the extent that folks are interested in the way this is played out in state courts, Professor Brandon Garrett and I wrote an article called The Myth of the Reliability Test that talks about the failure of the courts really to apply Rule 702 in a meaningful way. I had this slide, we put the slide together to show how influential the federal government's rules are in state courts. And it's, as it says, is 38 states have basically adopted this rule. And what's interesting as far as wrongful convictions go is that overwhelmingly, I think there's one or two wrongful convictions in federal court. Most of them are in state court because that's where violent crime is prosecuted. And all of these techniques that we know have resulted in wrongful convictions have nonetheless sailed through these purported evidentiary standards, so they don't have real teeth because they're not rigorously applied, and that's particularly true on the criminal side. So my point with this slide was showing that this has been adopted. There's a lot of words devoted to this, but the reality is it's not working.